Welcome to the Expertise Unlocked podcast, a part of IR Global, the largest international professional services network. I'm your host of the podcast, Jennifer Riggins. Today, we are sitting down with Thomas Curran of Thomas H. Curran Associates. Hi, Thom. How about we start off with introducing yourself and any relevant experience and qualifications?
Sure. As you said, I'm Thom Curran, of managing partner of Thomas H. Curran Associates. We're a boutique business law firm, primarily engaged in commercial litigation, insolvency, and insolvency litigation throughout the United States. And we also do a significant amount of cross-border litigation, primarily in the insolvency arena. I've been practicing in the insolvency area for approximately 37 years now.
And where can you practice law, since in the US that matters more?
I am licensed in federal courts in Massachusetts, in Connecticut, in Texas, but I regularly will practice in states all across the country. Again, primarily in federal court, and I do so pro hac vice basis, because primarily the types of insolvency litigation we're involved in end up in federal court.
Okay. Yeah, they're big ticket items, it looks like, if this is
Yes.
the case. So I always like to set the expectations of the listener. Who would benefit from listening to this conversation?
Um, well, we do quite a bit of work for business enterprises, private equity firms, lenders, creditors in the insolvency space. So that's certainly a group of parties who would benefit from it. Any business really that gets themselves involved in some sort of business dispute or insolvency dispute, whether it's they're attempting to collect or recover on a judgment or an arbitration award, or alternatively, on the other side, if an entity is attempting to fend off recovery efforts from someone who does have a judgment or an arbitration award. We do some work for borrowers as well, but primarily we're a creditor side litigation firm.
Okay, and I love a definition as a journalist. So what is insolvency in a brief way? Because I'm sure in the weeds.
It's really a very broad category that a broad term rather to describe the category of where there's a distressed, financially distressed situation, whether it's a bankruptcy proceeding, whether it's just a proceeding where a company or an entity is not paying their debts, and therefore there's issues of whether or not they're insolvent, and also there's quite a broad range of transactions that we kind of put in the insolvency area, where it's a distressed debt, where there's been a breach of a mortgage, or a breach of a loan, a business loan, or breach of an agreement to pay. And most times that is the result of one party not paying the other. So when it comes to international insolvency, it's really, the vernacular would be that, you're chasing the money around the world.
Okay.
And we like to say that when insolvency raises its ugly head, there are oftentimes hidden assets all over the globe.
Yeah,
And
I saw Cyprus and Switzerland mentioned in just the brief articles surrounding this story. So, plus it's centered in Ireland and the US,
right,
certainly.
that's also a result of our business community and environment now. It's really, almost every business is global in reach, and so certainly when we talk about recovery of assets or litigating over monies that are allegedly owed and not paid, we're talking about, jurisdictions all over the world.
Yeah, absolutely. So, with that in mind, can you introduce the case and give us a background? What are the players? What was at stake here?
Um, this case, I've been involved in it for 12 years. It started a couple of years before I got involved. Um, and I'll give you somewhat of a Reader's Digest version because it's a very long and complicated set of transactions, all relating to this one developer. Sean Dunne was one of the largest developers in the country of Ireland, and back in the time of the time period of the Celtic Tiger, very significant real estate boom in Ireland. Mr. Dunne was very successful in both residential and commercial real estate development, and he owed a significant amount of money to a number of banks and consortiums of the banks in Ireland. Right around 2008, Mr. Dunne and many of his companies began to default on his bank loans, and Ireland essentially has a governmental agency called referred to as NAMA, National Asset Management Agency, and they essentially took all the bad loans from the Irish banks and took them into their agency, similar to what the FDIC does in the US. However, NAMA took the bad loans into its agency, and it was NAMA's responsibility to administer those loans and collect the money. Mr. Dunne owed nearly $1 billion to Irish banks. And once NAMA attempted to embark on the administration of those loans and collection of those monies, of course, Mr. Dunne showed some significant recalcitrance in that, and he began his deception with regard to where the money went, his assets that he had, where those assets went, and how he was going to settle up his debts with the Irish government. He never did that. By 2010, the Irish governmental agency was attempting to collect and starting recovery actions against him.
Oh, which could be seizing of assets, homes.
That's correct. And what happened at that point is Mr. Dunne essentially signed off on agreeing to a judgment for the full amount that he owed. So he really didn't have any defenses to the money. He just claimed that he didn't have any money and he couldn't pay. And of course, that was not an acceptable response to the Irish government, since they had a significant amount of information on him that at one point in the very not too distant past, he had a significant amount of assets, far
Yeah.
more than what
Oh,
he,
like a $50 million house, even
yeah,
the most expensive 56 million euro house. Sorry, the most expensive residential property in Ireland.
that's correct. So once the Irish government got him to agree to the judgment, of course, he wasn't paying it. He fled to the United States, and he and his wife began a scheme whereby she would start acting as a developer in the United States, and he, of course, claimed that he was unemployed and he was just helping her along. Um, his
Okay.
wife's name was Gail Killilea, and
If he, yeah, sorry.
at that time she was central a gossip columnist for one of the newspapers in Ireland.
Oh, okay. But Ireland and the US are open allies. So could they just evade paying €1 billion because they moved to the US?
Well, what Mr. Dunne's move is that he essentially transferred much of his liquid and some of his illiquid wealth to his wife, and so therefore, when he went to the Irish government, he said, "I know I owe this money, but I don't have any assets. I can't pay. And oh, by the way, um, I've transferred my assets to my wife for various reasons that he came up with, and um, he was essentially claiming that he didn't have any assets and he really didn't have any ability to make money in Ireland any longer. So he was going to help his wife relocate to the United States. She was embarking on a real estate development career. Of course, all of that was just a ruse. It was really him acting in her name.
But also, if they're married, wouldn't they have? It seems strange to me that you would go that close because often couples are filing taxes together and like, would it be that different?
Yes, well, he had some transfers to one of his sons, um, to his son in Ireland, but he he really um, he didn't have many choices as to where he was going to, essentially funnel his cash to, and he did that to Ms. Killilea back in the years leading up to the time that he moved to the US, which was, in 2012, 2011, 2012. And at that point in time, NAMA engaged our firm to sue him in the US to attempt to recover on some of these transfers that they knew about and investigate further transfers. At that point in time, Mr. Dunne made a strategic decision that he knew that the government of Ireland was attempting to force him into an involuntary bankruptcy in Ireland, which at that time, Ireland's bankruptcy regime was very, very tough. In other words, some would even refer to it as draconian. And so if you filed for bankruptcy or were forced to be a bankrupt in Ireland, it was a long, very distasteful process for the debtor, especially somebody like Mr. Dunne. So he make the calculation that if he filed a bankruptcy in Connecticut. He was here in living in Greenwich, Connecticut, that he could essentially, jump the gun and file in Connecticut bankruptcy so that he wasn't forced into a second bankruptcy in Ireland. That's what was his plan. It didn't work. We were able to not only deny his discharge in the bankruptcy in the US for fraud, so he didn't get any benefit for the bankruptcy in the US, but also we were able to get the court to agree, the US court, that his major creditor, the government of Ireland, should be able to pursue him in bankruptcy in Ireland at the same time. And as far as I know, I've been practicing bankruptcy and insolvency law for 37 years, and I haven't come across a case where somebody was simultaneously declared bankrupt in two different jurisdictions, both in this case, the United States and Ireland. So he found himself in quite a bit of a pickle because his plan didn't work. He was stuck in a bankruptcy in the US. He was still being prosecuted for a bankruptcy in Ireland, and he lost his discharge, so he would not be discharged of any of his debts in the US. And the US trustee that was appointed to the case decided that he had an obligation to Mr. Dunne's creditors to pursue the recovery of all those transferred assets around the world and recover those assets for the benefit of Mr. Dunne's creditors. So the bankruptcy move in the US didn't work out very well for him.
Yeah, I would say so, because it just doesn't make sense to me why he would be absolved from having to pay his debt if he moved countries, especially to an ally, not like one of those countries that it's a bit of a different situation. It just was surprising to me. So last week, I believe it was now, SCOTUS, the US Supreme Court, considered the case, didn't pick it up. So that means the final ruling stands. But what does that mean? Is that creating precedent? What does this mean for other organizations?
Well,
Why does this matter?
It's the final chapter in a long, arduous, story from those very early days when he filed for bankruptcy in New Haven, Connecticut, where he attempted to essentially convince the court and the trustee that he didn't have any assets, that any assets that he transferred to his wife were simply, gifts for love and affection, or that he changed that tune to obligations that he had to his wife. And he essentially had assets all over the world. He had real estate assets that he transferred in Ireland. He had money assets in bank accounts in Ireland, in England, in Geneva, Switzerland, and he had a hotel on the beach in South Africa, Cape Town, South Africa, that he transferred the ownership interest into a constellation of entities that he created, all ending up ownership in his wife and his kids with and some of his other family members. But he ultimately controlled it, and he was still siphoning off money from that entity, that South African hotel. And of course, he just before all of his debt came crashing down on him, he purchased the most expensive single-family home in Ireland, in the history of Ireland, 56 million euro back in 2005. He bought a home, and he attempted to transfer that to his wife. He wasn't successful with that, and it ended up that he attempted a second time on the eve. In fact, the day that he filed for bankruptcy in Connecticut, he effectuated that transfer to his wife. So that was going to get unwound. And the bankruptcy in Connecticut took several years to move through its process. And eventually the trustee sued Mr. Dunne's wife and other some entities that she controlled to recover all that money. There was we believed upwards of 50 to 100 million euro transferred. And so that took a series of lawsuits, essentially in the US and in Ireland and the UK. And then a series of lawsuits putting attachments and seeking freezing orders in Cape Town, South Africa, so that the assets could be frozen until the courts in the US could kind of figure out whose assets these really were. Were they Sean Dunne's? Should they be returned to Sean Dunne's estate to distribute to his creditors? That was our position. We were then hired by the bankruptcy trustee to litigate those cases. And we ended up with a 5-week jury trial, which I tried in the federal district court for the District of Connecticut in New Haven. And was that was a significant event. The jury came back and found that Mr. Dunne, he had not only constructively conveyed his assets, in other words, he conveyed his assets fraudulently under the law, but also he intended to fraudulently, intentional fraud he committed, and therefore all of those assets from his wife had to come back into the estate, and the jury awarded us a little over 21 million euro. In the end of the day, ended up to be a little north of that in dollars. And so, of course, that case had to, that verdict, which came down in June of 2019, had to work its way up to a final judgment in federal district court in Connecticut. That was challenged, and it was appealed to the Second Circuit Court of Appeals. And then it was, of course, Mr. Dunne and Ms. Killilea tried to appeal that with a cert of certiorari to the United States Supreme Court. The Supreme Court did not take it up and agreed with us that there was nothing that the Supreme Court should do to alter what the lower courts have found. What is it? What it was interesting about this case was not just its length and its breadth of fraudulent conveyances, but the lengths that the Dunnes went to conceal and hide their transfers, to conceal the fraudulent nature and the intentional fraudulent nature. They, in fact, at trial, it was disclosed that they asserted that they had actually obtained a divorce in Switzerland, and that the divorce decree required Mr. Dunne to transfer 100 million euro to his wife, and that's really why he transferred the money. However, we were able to prove a trial and convince the jury that, in fact, that divorce was just a sham divorce, In fact, on around the same time that they was allegedly becoming divorced in Switzerland, they were searching for a new home to live in Greenwich, Connecticut, with their family. So they were clearly together. The whole divorce in Switzerland was a sham, and we believe that the jury believed that and disregarded that defense. So I think what's important about the case is that fraudulent transfer cases, fraudulently concealing money, and transferring money, even to close associates, even to your family members, is always susceptible to recovery by the creditors and or their representatives, no matter where it is in the world. And usually the cases will be brought in the jurisdiction where the parties and most of the assets appear to be. But what we demonstrated in this case is that we were able to bring a claim to the jury under several different theories and in fact several different laws, countries' laws, regimes. So there were some transfers that we were telling the jury they needed to analyze under Irish law, some transfers they needed to analyze under Connecticut law, some transfers they needed to analyze under U.S. federal bankruptcy law, some transfers they had to analyze under South African law. And in fact, those transfers were made under, for South Africa, it was the Rand. For Irish transfers, it was euros. For any transfers that happened in England were, of course, pounds. And so what we found was that in these types of cross-border situations, the takeaway is that if you have a cross-border case, if you have a dispute that has tentacles that reach across the globe, invariably there's going to be one main locus where you're going to bring the case, or the first case, and then other cases will grow off of that. But you can always, in federal court, generally bring cases under laws of different states and different countries and try and explain why these various this various conduct by the transferring parties should be unwound. And that this case was a significant kind of example of that.
A success in the fight against money laundering and fraud.
That's right.
I mean, it's impressive. And so you had mentioned that I've heard $1 billion in there in assets. I've heard 100 million, but then it said on the July 2021 ruling that, or June 2021, that nearly 18 million euro verdict in favor of the trustee against Killilea, his wife. Is that different from what he owes? Do they owe different amounts then, or his ex-wife? I think they're divorced now. Really? Maybe not.
Yes. Well, sure. That's always the question is are they divorced or are they not? Is their divorce in England any more real than the divorce in Geneva, Switzerland was all those years ago? We don't know. But answer your question, the jury verdict in roughly 18.5 million euro was increased by the U.S. court by approximately, I think, 1.4 million with post-petition interest and judgment amounts. But that's what, and ultimately that amount with interest during the time of the chase, that's what we were able to find, the transfers we were able to find and recover. So that was recovered by the trustee. There's two other figures, and that is the money that he owed was still close to $1 billion. So
Yeah.
he still owes more, and he doesn't have a discharge, so he'll owe that for quite some time. And we believed, I think I told you at the beginning of this, that we believed that he transferred to his wife and family members in excess of 60 million euro, could have been as high as 100 million. He, in fact, testified several times that, yes, I gave my wife 100 million euro for love and affection. So, whether that was true, whether he was over exaggerating the amount of money that he transferred to her and the amount of that, or was he including valuation of assets? What we do know is we were able to find and recover just over 20 million euro in rand. Did he get away with more? Maybe. We just don't know.
Wow, it's a staggering, it's a amount of money that someone like myself could not truly imagine as a journalist need to get to property. So we are on the IR Global podcast. So I'm guessing there's some sort of connection here that maybe you leverage the network in some way if you were dealing with so many legal cases and banks in so many different countries.
We did I can answer that question two ways. We did at the end of the case, because the vast majority of this case was litigated prior to my joining the IR Global in 2021. But once I did have some assistance in the back end of this case. But the other part of it is that it was one of the precipitating factors of me joining IR Global because of this, specifically this case. I've been involved in other cross-border cases, none of them as large as this, none of them as significant as this case. And it truly showed me the nature of the team that has to be put together in order to litigate. We had several different law firms from all over the world working on this case as a team, and I was essentially the running the litigation team. And so IR Global is the type of network that our firm really needed in order to really be successful in these types of cases. So it was this experience that really led me to embrace the type of collaboration that IR Global has to offer, and really IR Global, I think, is the best at this type of global force, all interconnected, and all acting as one when you have a case. And when I have a cross-border case this size or even larger, I have no doubt whatsoever that I can put together an IR Global team very quickly. I know the people, I know the experts involved, and it's critical in this type of case.
And this case isn't over, just this portion of it is over, I assume, right?
That's right.
You'll be looking for money for a while.
There are other aspects of the case that may go on in the future. Mr. Dunne's bankruptcy is still open, I believe, in Ireland. So there is cases like this tend to last for decades.
Seems so. So my understanding, because the Supreme Court did not, 4 justices didn't want to hear the case, they didn't set any precedent. But I guess, is this a kind of blueprint for doing these large scale insolvency cases in the future? Because there are certainly other people trying to do this globally.
Yes, I think that the Supreme Court and the Second Circuit Court of Appeals really upheld the jury trial, the 5-week jury trial, where we brought all claims against Killilea and her entities and Mr. Dunne. And so what the higher courts, the Fifth Circuit Court of Appeals and the Supreme Court really did was say the way this case was litigated in the district court, the federal district court in front of Judge Meyer was, was correct. The law that Judge Meyer applied and the rulings that he made during the case, some significant rulings with regard to who could give expert testimony, and what type of foreign law could be the subject of expert testimony. That was an issue that Judge Meyer decided, and the higher courts said he decided it correctly. So it was certainly a blessing on Judge Meyer's blueprint of how do you handle one of these massive fraudulent conveyance asset recovery cases when you're dealing with assets all around the world, you're dealing with regimes, multiple regimes, and you have a jury, a U.S. jury that you have to explain all this to, and certainly you're going to have experts that are going to try to testify about the law in different countries, and Judge Meyer took a very balanced approach there, and the correct approach, according to the Court of Appeals and the Supreme Court, that experts, their position is to explain the law in general. They cannot take that next step and apply the facts to the law. Only the jury can do that in our system. And that was a critical component of this case, where the jury really took all of the information about the various jurisdictional differences in the law, and there were some, and they applied the facts to what they learned in the law. And our juries are very, very smart, very intuitive, and they really, if the law is explained to them sufficiently, they can do their job and apply the facts of the law and issue verdicts. And that's exactly what they did in this case. So yes, I think the blueprint that Judge Meyer followed worked, and it is I think a model of how to recover assets in an insolvency setting, which deals with a myriad of fraudulent conveyed assets all over the world, and how you should go about that and how you should present the case to the jury.
So you're kind of a lawyer and a spy.
Yes, that's many have described it that way.
Thank you so much, Thom. Is there anything else I should be asking you about this case?
No, I think we've covered it. It's we could talk about the case for hours. But that gives you a really good sense of this case and what it means for other cross-border insolvency cases.
If our listeners want to touch base with you because maybe they're in a similar situation on one side or the other, hopefully the side of the law, uh, how do they get in touch with you?
My firm name goes by the acronym THCA. That's Thomas H. Curran Associates. We're our website is THCA Law. And you can just Google me and you'll find me that we have an office in Boston, Austin, Texas, New York, and we have an office in London. So you look up Thomas H. Curran and you'll find our law firm, THCA. And again, we handle these cases all over the world, so there's not a jurisdiction that we can't help out in with our team from IR Global. And you can find us in the IR Global website. If you look at IR Global and you look under insolvency, you'll find me.
Fantastic. And that's a great way to network and learn from everyone and for you to find new partners too. Thank
Right.
you so much, Thom. And thank you, listeners. These Expertise Unlocked podcast episodes are meant to be educational resources from experienced lawyers, accountants, and financial advisors, your trusted advisors, with extensive knowledge on topics you as professionals need to know more about. To learn more about IR Global and its services, please visit irglobal.com. And if you found this episode useful, please consider sharing it.